So, welcome to Law and Society. Today I'm going to do a quick take because there's news that the Supreme Court of the United States has denied certiorari to Jack Smith's petition for certiorari for the Supreme Court to review the governmental immunity interlocutory case that Donald Trump brought uh, in order to stop the DC criminal conspiracy trial. So it's not the criminal conspiracy trial. It's not the substance of the criminal conspiracy trial that has been appealed. It hasn't even been adjudicated yet. That trial starts March 4th. What the Supreme Court has done here is said, no, we're not going to hear the immunity case. The Supreme Court generally does not provide us with an explanation of why certiorari is denied, but there are many indications as to why. First of all, the DC Circuit Court of Appeals has already expedited and, as far as they can, expedited the case of the governmental immunity. And I believe that the Supreme Court denied certiorari because it wants to see what the DC Circuit Court says. And that is the appellate process. And it has been expedited in the appellate process. The indication here is just that the Supreme Court of the United States doesn't feel that it is so urgent that this immunity issue, about 2.5 months before the trial, because they think that there is enough time, that the issue has been expedited in the appellate level, and when it gets to them, they will see it, as in the normal course, and maybe expedite the ruling and hearing. It is a negative in the sense that it doesn't really expedite or hasten the interlocutory sub issue of governmental immunity, because that is governmental immunity is not what the case is about. Governmental immunity is one of Donald's defenses. He brought that up in pre-trial motions to dismiss the case. Judge Tanya Chutkan wrote an extensive explanation of why that doesn't apply. Governmental immunity doesn't apply, and then it went and then Donald Trump appealed to the DC Circuit, saying that immunity applies. Then Jack Smith wrote to expedite wrote to the DC Circuit to expedite the trial of the governmental immunity sub issue that Donald Trump is now litigating. Mind you, all of the motions to dismiss that Donald Trump puts forward and then doesn't preserve for after trial, but instead goes interlocutorily in the middle of the pretrial process to the appellate courts, they're all designed to stay the court's procedure in the substantive criminal conspiracy case against Donald Trump. And to that end, Donald Trump has been successful because once the case went on the docket in the appellate circuit, the case below was stayed. The discovery processes were stayed. And the only thing that remains in effect is the gag order that Judge Tanya Chutkan imposed, and then the DC Circuit of 3 judges affirmed. Donald Trump is also appealing that to the full bench of the DC Circuit, the gag order ruling from the DC Circuit to the en banc, which means all 9 of the judges of the DC Circuit. So we'll see if the DC Circuit accepts that gag order appeal. We have to wait for the next 2 weeks to see what the filings are in the DC Circuit Court of Appeals for the governmental immunity case. I have been talking about governmental immunity for about 3 years, and honestly, it's exhausting, but it will come up. And until SCOTUS really solidifies and tells us what governmental immunity and the scope of it is, it will keep going through the federal circuit court. So I'm hoping that the expedited appellate court ruling will expedite the Supreme Court. Now, you know, Donald Trump's group is trying, lawyers are trying to push the March 4th, 2024 trial on the criminal conspiracy as much as they can with all these motions. So you will see today a lot of right wing media making a big deal about the Supreme Court's denying Jack's certiorari, petition for certiorari uh, before judgment, because it's before the judgment. It hasn't happened. So once the judgment happens and once the ruling comes out, if it is appealed to the Supreme Court, which it most likely will be, if nothing else, but for the interest of delay, which Donald Trump wants, they will get to address the issue of governmental immunity. And I hope they tackle the issue and clarify it for the future, so we don't have cases where executives have a criminal case against them and then they bring up all these interlocutory issues to delay the judicial process. So with that, I just wanted to give you a heads up on this denial of certiorari. That's end of the substantive. And let's see, hey, Deb, thank you for being here. Dank Dude Smoke a Lot, how are you? I haven't seen you before. Thank you for being here. Let's see what you have to say. Yeah, they want to see how the lower court rules. Yeah, they also have to deal with the so Donald Trump has until January 4th to appeal that order from the Colorado Supreme Court, or the stay that Colorado Supreme Court put on the order themselves will be lifted, and Secretary of State would have to remove Donald Trump from election ballots. So I am assuming that Donald Trump's attorneys are right now very busy writing the brief for the Supreme Court, challenging and bringing up the Colorado Supreme Court's opinion. That's happening. It would be near impossible for me to conceive that Donald Trump wouldn't take that to the Supreme Court. So the Supreme Court is busy. And then don't forget the obstruction of official proceedings appeal that the Supreme Court has already granted certiorari on. That has to do with obstruction of an official proceeding and a technical statutory interpretation of the general obstruction statute. So the Supreme Court will see whether the obstruction statute was properly applied and whether certain elements of that statute are required and were not had in the cases that had the obstruction stemming out of January 6th. Remember, obstruction statute is just one part of Donald Trump's case, the case against Donald Trump. So even if the obstruction statute thing is ruled on in saying that the obstruction statute cannot be applied in the January 6th cases, it would take away the obstruction statute from Donald's indictment and also from the indictment of many others. But remember, the obstruction of an official proceeding was just one of the charges that most of these people were charged with, including Donald Trump. So the other charges don't go away simply because the Supreme Court says the obstruction statute was not properly applied. So now I've gone off into the other cases. It's difficult not to, but the Supreme Court is busy. And I believe that may be part of the reason why the Supreme Court didn't grant certiorari for this expedited certiorari before judgment, before the DC Circuit can rule on it. So still keep the March 4th, 2024 trial date in mind. Keep January 4th in mind, which is the last date for Donald Trump to appeal to SCOTUS about the Colorado case. And January 2nd is the last date for the filing of the cases in the DC Circuit Court of Appeals for the governmental immunity appeal. So with that said, Thank you so much for being here. Please like and subscribe and share. It really helps me out a lot. And I'll come back and I'll speak with you about more relevant topics when they come up. And just as I said, more relevant topics, the thing came up about Michigan. So I'm going to briefly touch on the Michigan thing. It turns out that there's a video recording of Donald Trump pressuring election workers, officials, to not certify the votes in Wayne County in Michigan. And I would hope that Wayne County prosecutors and the AG of Michigan are looking into this, and it makes you wonder, what about the other states? We know that Rusty Bowers was pressured in Arizona. We know that thing about Scott Perry's phone with in Pennsylvania. So Scott Perry's phone information has been ordered. Chief Judge of Federal District Court of the District of Columbia has ordered Scott Perry to turn over 1,600 text messages and messages from his phone because they are not protected under the speech or debate clause. Mind you, this is a second time around. When Scott Perry appealed this case to the DC Circuit Appellate Court, the court remanded it back to the district court, saying you have to go through each of the messages and see if speech or debate clause applies. They went through each of the messages, and after 2 months of going through that, the document was filed at, I think, last week, and we got a sneak peek of it because the court docket, whoever was doing it, made a mistake and posted it publicly. But now we have the public information that Judge Boasberg has ordered Scott Perry to turn the 1,600 over that have already been through the appellate review. So it's unlikely that Scott Perry would want to, go through the appellate process again because they have already done that. So that's Pennsylvania, and then there's Rusty Bowers, Arizona, and now we're getting Michigan. Michigan, I hope that they look into this, and I hope, just like Georgia, they put country over political considerations. Well, he tried it in Georgia, but the call failed in Georgia. I believe, and I don't know the facts of the Michigan case yet. I believe that the audio recording is of a bribery, and then there has been an overt act from the other side that acknowledges the bribe. I'm not entirely sure. So the Michigan case may be even more clear. But my question for the Michigan case would be, why has the whistleblower waited this long? I want to be as factual as possible in these cases, and not to give all of y'all the wrong impression, but it does weaken the case when you have been sitting on a phone call, an incriminating phone call of a person who has been indicted for similar things in more than one jurisdiction in our country. Why have you been sitting on it for the last 3 years? What is the thought process of you not releasing it? So I see, Mr. Smoke-a-Lot, I don't know the RICO cases very well, so I cannot say that it would be grounds for RICO. We'll just have to wait and see. I mean, it may very well be. I'm not a RICO expert, so I can't talk about that. And I haven't read up on the RICO statute for federal and all of that. I've only read part of whatever the RICO thing is with Georgia. So, I mean, it would be grounds for it, but the primary ground in the Michigan thing in the phone call seems to be a bribery charge. So, we'll see. Anyway, thank you for being here, and thank you for asking questions, and thank you for engaging. That's exactly why I want to do these things. And even if there's only a few people, I welcome it. And I think that this conversation, this exchange of ideas, this explanation of ideas at a very grassroots level and even on the macroscopic level helps to make each other understand how important it is that we talk about our country, our politics, and the rule of law. So thank you so much, and I will see y'all soon.